diplomatic approach. Since its independence in 1971, Bangladesh has made its mark in the international arena. Diplomatically, the country follows the principle of friendship towards all, malice towards none. It is a member of the non-aligned movement and has maintained a neutral stance in global politics, not aligning itself with any major world power. International memberships and contributions. Bangladesh joined the Commonwealth of Nations in 1972 and became a member state of the United Nations in 1974. Since then, the country has actively contributed to the goals of the UN by ratifying various treaties and participating in UN peacekeeping operations in dangerous conflict zones. Bangladesh and the Muslim world. As a Muslim-majority country, Bangladesh is a member of the Organization of Islamic Cooperation, OIC, and maintains positive relations with Muslim nations worldwide. Signatory to international treaties, Bangladesh pays close attention to its national and regional interests and has become a signatory party to many important international treaties. It has ratified 8 of the 9 core human rights treaties, including the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the Convention on the Rights of the Child, CRC. Challenges in women's and children's rights. Despite its commitment to international treaties, the present situation regarding women's and children's rights in Bangladesh falls short of international standards. There is a need for improvement in ensuring the rights and well-being of women and children in the country. Status of international law in Bangladesh. The application of international law in Bangladesh depends on the political goodwill of the government. While the constitution does not explicitly outline mechanisms for treaty implementation, the executive branch holds the power to enter into international treaties. The legislative body is responsible for incorporating international rules into domestic legislation, and the judiciary has the authority to interpret and decide on the applicability of international treaties within the country. Understanding how international law is applied in Bangladesh sheds light on the country's diplomatic engagements and its commitment to upholding human rights and international cooperation. Continuous efforts are required to bridge the gap between international standards and the actual implementation of rights in Bangladesh. Understanding the use of force in international law. Introduction. The use of force is a crucial aspect of international law, working alongside principles such as territorial sovereignty, state independence, and equality. While political and non-legal factors also influence the role and manifestation of force, the law aims to provide mechanisms to restrain and punish acts of violence. Just war to United Nations. A brief history. The concept of the just war emerged as a result of the Christianization of the Roman Empire and the abandonment of pacifism by Christians. It allowed for the use of force if it aligned with divine will. The just war doctrine drew from Greek and Roman philosophy and was employed to maintain societal order, punishing wrongs and restoring peace. However, with the rise of European nation-states, the concept evolved and became linked to state sovereignty. Attempts at peaceful resolution before resorting to force became necessary. The idea of just war also encompassed the protection of innocent civilians and the proportionate use of force. The role of the League of Nations and the Kellogg-Briand Pact. After the First World War, efforts were made to prevent unjust wars and establish an international institution overseeing global conduct. The League of Nations was created with the objective of resolving disputes through arbitration or judicial settlement. Although war was not explicitly prohibited, the League aimed to restrict it to tolerable levels. In 1928, the Kellogg-Briand Pact was signed, renouncing war as an instrument of national policy. UN Charter and the Prohibition of Force. Article 2(4) of the UN Charter declares that members must refrain from the threat or use of force against the territorial integrity or political independence of any state. This principle is considered customary international law and binding for all states. The term force encompasses situations involving violence that fall short of a formal state of war. The 1970 Declaration on Principles of International Law further elaborated on this provision, stating that aggression, violations of international frontiers, reprisal acts, denial of self-determination, and incitement of civil strife or terrorism are prohibited. Exceptions and collective measures. Exceptions to the prohibition of force exist in relation to collective measures taken by the United Nations and the right of self-defense. Article 2(6) of the Charter empowers the UN to ensure that non-member states also adhere to these principles for the maintenance of international peace and security. Interpretation of force. The interpretation of force in Article 2(4) is a subject of debate, including whether it includes economic force such as boycotts or embargoes against states or groups of states. While the provision remains unmodified, the Charter's preamble emphasizes the need to limit the use of armed force. Conclusion. Understanding the use of force in international law is vital for maintaining peace and order among nations. The development of principles and agreements over time reflects the collective efforts to prevent unjust wars and promote peaceful resolutions to conflicts. While the prohibition of force is a fundamental principle, exceptions exist, and the interpretation of the term force continues to be debated.
The role and function of the United Nations Security Council. Introduction. The United Nations Security Council, UNSC, is responsible for maintaining international peace and security. With 15 members, each having one vote, the UNSC plays a crucial role in addressing threats to peace and acts of aggression. In this article, we will explore the purpose of the UNSC, its decision-making process, and the enforcement measures it can take. Primary responsibility for peace and security. According to the UN Charter, the primary responsibility for maintaining international peace and security lies with the Security Council. All member states are obligated to comply with the decisions made by the Council. The Council takes the lead in determining the existence of threats to peace and aggression and encourages peaceful means of dispute resolution. However, in certain cases, it can resort to imposing sanctions or authorizing the use of force to restore peace and security. Sessions and membership. The Security Council held its first session in 1946 in London and has since established its permanent residence at the United Nations headquarters in New York City. It has also conducted sessions in other cities, including Addis Ababa, Panama City, and Geneva. To ensure prompt action, a representative from each member must be present at all times at the UN headquarters. Membership composition. The Security Council consists of 15 members, with 5 permanent members, China, France, Russia, the United Kingdom, and the United States, and 10 non-permanent members elected by the General Assembly. The selection of non-permanent members takes into account their contributions to international peace and security and geographical representation. Decision-making and veto power. Each member of the Security Council has one vote. Procedural matters require a positive vote from 9 members, while other matters need an affirmative vote from 9 members, including the concurring votes of all 5 permanent members. The 5 permanent members hold a special privilege known as the right to veto, which allows them to reject resolutions by casting a negative vote. Functions and powers. The Security Council focuses on resolving disputes and preventing hostilities. It can recommend peaceful means of settlement, undertake investigations, appoint special envoys, or request the Secretary-General's assistance. When conflicts escalate, the Council aims to bring them to an end promptly. It can issue ceasefire directives, deploy peacekeeping forces, or resort to enforcement measures like sanctions, arms embargoes, or collective military action. Role of non-member states. Non-member states have limited participation in Security Council discussions. If a dispute directly affects a non-member state's interests, it can participate in discussions without voting rights. Additionally, a non-member state involved in a dispute can be invited to participate in discussions related to that dispute, subject to conditions set by the Council. The United Nations Charter, building an international community. The United Nations Charter, signed in 1945, is a crucial document that established the United Nations as an international organization. It came into force on October 24, 1945, following the United Nations Conference on International Organization held in San Francisco. This article explores the significance of the Charter and its role in shaping the international community. Founding of the United Nations. Before the Charter's finalization, several conferences and agreements paved the way for the 1945 San Francisco Conference. This conference, attended by representatives from 50 countries, drafted and unanimously adopted the Charter. China was the first country to sign the Charter, followed by the USSR, the United Kingdom, France, and other nations in alphabetical order. The Charter came into force after ratification by the 5 permanent members of the Security Council and a majority of other countries. The purpose of the Charter. The Charter's primary purpose is to save future generations from the devastation of war and establish conditions for maintaining peace, justice, and respect for international law. It emphasizes fundamental human rights, equality among nations, and the promotion of social progress and better standards of living. The Charter also encourages tolerance, cooperation, and peaceful resolution of disputes. The constitutional nature of the Charter. While the Charter is an international treaty, it holds a unique status as a constitutional document. It embodies principles, ideals, and moral sentiments rather than merely describing rights and obligations like other treaties. During the San Francisco Conference, President Truman compared the Charter to a constitution, highlighting its dynamic nature that allows for growth and improvement over time. Scholars and experts have recognized the Charter as a constituent act and the beginning of international constitutional law. The role of the United Nations organs. The Charter establishes several principal organs of the United Nations, including the General Assembly, Security Council, Economic and Social Council, Trusteeship Council, International Court of Justice, and Secretariat. These organs work collectively to achieve the purposes of the United Nations, maintaining peace and security, promoting cooperation, and addressing global challenges. Amendments and structure of the Charter. The Charter can be amended by a two-thirds majority vote in the General Assembly and ratification by two-thirds of the UN members, including all permanent Security Council members. Over time, the Charter has undergone 5 amendments, modifying the composition of the Security Council, Economic and Social Council, and reviewing processes. The Charter consists of 19 chapters, covering various aspects of the UN's work, from peacekeeping to human rights and international cooperation. Conclusion. The United Nations Charter serves as both the Constitution of the United Nations and the international community. It outlines the organization's purpose, principles, and structure, emphasizing peace, cooperation, and the well-being of humanity. As a living instrument, the Charter has evolved to meet the changing world conditions and continues to guide the United Nations in its pursuit of a more peaceful and just world. The role and functions of the United Nations General Assembly. The United Nations General Assembly, UNGA, is the primary decision-making and representative body of the United Nations. It serves as a platform for member states to discuss a wide range of global issues and make recommendations. This article provides an overview of the UNGA, its composition, functions, and procedures, highlighting its significance in addressing global challenges and promoting international cooperation. Composition. The UNGA consists of all 193 member states of the United Nations, with each member having an equal vote. It meets intensively from September to December each year and discusses specific issues through dedicated agenda items, leading to the adoption of resolutions. Functions and powers. The functions and powers of the UNGA are outlined in Chapter 4 of the UN Charter. The UNGA plays a vital role in standard setting, the codification of international law, and the promotion of international cooperation in various fields. It has the authority to make recommendations to member states or the Security Council on matters within its competence. Key decisions. The UNGA is responsible for appointing the Secretary-General based on the Security Council's recommendation, electing non-permanent members of the Security Council, and approving the UN budget. It addresses global challenges such as racism, intolerance, inequality, climate change, poverty, hunger, and armed conflict. Sustainable Development Goals. In 2015, the UNGA agreed upon the 17 Sustainable Development Goals, SDGs, as part of the post-2015 development agenda. These goals aim to transform the world by 2030 and address various social, economic, and environmental issues. Procedures. The UNGA adopts its own rules of procedure, conducts regular annual sessions, and may hold special sessions as needed. It also establishes subsidiary organs to assist in performing its functions. The UNGA operates through 6 main committees, each dedicated to specific areas such as disarmament, economic and financial matters, social and humanitarian issues, and more. Voting and decision-making. Each member state in the UNGA has 1 vote. Important decisions, including recommendations on peace and security, elections of council members, and budgetary questions, require a two-thirds majority. Other questions are decided by a simple majority. However, most resolutions are adopted through informal consultations and consensus. Conclusion. The United Nations General Assembly serves as a crucial platform for global cooperation and decision-making. It provides member states with an opportunity to address pressing global challenges and make recommendations. Through its functions and powers, the UNGA plays a vital role in promoting international peace and security, sustainable development, and the protection of human rights. By coming together and charting a course for the future, the UNGA contributes to a more just, inclusive, and sustainable world.
International Court of Justice, ICJ, resolving disputes between nations. The International Court of Justice, ICJ, also known as the World Court, is a significant organ of the United Nations, UN, responsible for settling disputes between countries based on international law and providing advisory opinions on legal matters. Established in 1945, the ICJ serves as the primary international court for resolving general disputes between nations, with its rulings and opinions serving as important sources of international law. While the ICJ is often regarded as the main means for resolving state disputes, only a few cases are referred to the court for judicial settlement each year. However, even a single case can have significant political and legal consequences, as demonstrated by notable cases like the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina v. Serbia and Montenegro, 2007. And the advisory opinion on the accordance with international law of the Unilateral Declaration of Independence in respect of Kosovo, 2010. The ICJ functions as the principal judicial organ of the UN and is located at the Peace Palace in The Hague, Netherlands. It is composed of 15 judges elected by the United Nations General Assembly and the Security Council, serving 9-year terms. The court is assisted by a registry and operates in English and French as its official languages. According to Article 1.1 of the UN Charter, the primary goal of the ICJ is to maintain international peace and security by peacefully resolving international disputes. Article 2.3 emphasizes that member states should settle their disputes through peaceful means, ensuring international peace, security, and justice. To achieve peaceful settlement, the ICJ provides various means outlined in Article 33.1 of its statute, such as negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements, or other peaceful means of the party's choice. The ICJ was established as the successor to the Permanent Court of International Justice, PCIJ, which was created by the League of Nations in 1920. The statute of the ICJ draws heavily from the PCIJ statute, and the decisions of the PCIJ remain valid. All UN member states are party to the ICJ statute, allowing them to initiate contentious cases, while advisory proceedings can only be requested by specific UN organs and agencies. The ICJ stands as one of the 3 general, universal, and permanent judicial institutions for dispute settlement, alongside the Permanent Court of Arbitration and the International Criminal Court. While specialized tribunals exist for specific matters, the ICJ holds a broader jurisdiction for resolving disputes. The applicable laws governing the ICJ settlement of disputes are outlined in Article 38 of its statute. The court is directed to apply international conventions, international custom, general principles of law recognized by civilized nations, judicial decisions, teachings of highly qualified publicists, and equity. Parties may also grant the court the freedom to decide based on what is fair, known as ex equo bono. The ICJ consists of a panel of 15 judges elected by the UN General Assembly and the Security Council. Each judge must be of high moral character, possess the qualifications required for the highest judicial offices in their respective countries, and represent different nationalities. They collectively reflect the main civilizations and legal systems worldwide. The election process for ICJ judges involves nominations by national groups, preparation of a list by the Secretary-General, and independent elections by the General Assembly and the Security Council. Judges serve 9-year terms, with the possibility of re-election, and must abstain from political or administrative functions and any other professional occupation. They enjoy diplomatic privileges and immunities while engaged in court business. Understanding the International Court of Justice, ICJ. Introduction. The International Court of Justice, ICJ, is an important judicial body that settles disputes between states based on international law. In this article, we will explore the jurisdiction of the ICJ and the different ways in which states can access the court. Membership and jurisdiction. According to Article 93 of the UN Charter, all 193 UN member states are automatically parties to the ICJ statute. Non-UN members can also become parties to the statute through a specific procedure outlined in Article 93.2. However, being a party to the statute does not automatically grant the court jurisdiction over disputes involving those parties. Types of cases. The ICJ deals with 3 types of cases: contentious issues, incidental jurisdiction, and advisory opinions. Contentious cases involve disputes between states and are the primary focus of the court's jurisdiction. Advisory opinions can be requested by certain agencies, including the General Assembly and the Security Council. Access to the court. Only states can be parties in contentious cases, as stated in the ICJ statute. Access to the court is separate from jurisdiction, and simply having access does not guarantee the court's jurisdiction in a particular dispute. Parties must consent to the court's jurisdiction, which can be established through various means. Means of consent. States can refer a matter to the court through different methods, including special agreements, compromissory clauses in binding treaties, and the optional clause system. Special agreements are ad hoc consents given by disputing parties at the time of a specific dispute. Compromissory clauses in treaties provide consent in advance, making jurisdiction compulsory. The optional clause system allows states to give consent in advance by signing treaties with jurisdictional clauses. Examples of jurisdiction. Many multilateral and bilateral treaties include jurisdictional clauses that grant the ICJ jurisdiction over disputes related to those treaties. For example, the Pact of Bogotá provided jurisdiction in the Nicaragua v. Honduras case, and the Genocide Convention granted jurisdiction in the prevention of genocide cases. Bilateral treaties, such as the territorial dispute case between Libya and Chad, can also establish jurisdiction. Understanding the International Court of Justice, ICJ. Introduction. The International Court of Justice, ICJ, is a powerful institution responsible for resolving legal disputes between countries. In this article, we will explore the key aspects of the ICJ, including its jurisdiction, procedures, interim measures, intervention applications, and the enforcement of its decisions. Jurisdiction and procedures. The ICJ has the authority to create its own rules and follows the Rules of Court of the International Court of Justice 1978. When a case is brought before the ICJ, the applicant presents a written memorial outlining the court's jurisdiction and the merits of its claim. The respondent has the option to accept the court's jurisdiction and file its own memorial addressing the merits of the case. If the respondent objects to the court's jurisdiction, preliminary objections are raised and ruled upon before the court addresses the merits of the case. Inadmissibility arguments may also be presented, questioning the justiciability or legal dispute nature of the issue. Additionally, objections can be made if all necessary parties are not present before the court. Interim measures. During the proceedings, either party can request provisional measures from the court to maintain the status quo until the case is heard. These measures, similar to interlocutory injunctions in the United States, aim to protect the rights of the parties involved. Article 41 of the ICJ statute empowers the court to grant provisional measures if it has prima facie jurisdiction over the case. Intervention applications. In certain cases where a third state's interests are affected, that state may seek permission to intervene in the proceedings as a full party. Article 62 of the ICJ statute allows states with a legal interest to apply for intervention. The court has the discretion to accept or deny such applications, and historically, intervention applications have been rare. Enforcement of decisions. While the ICJ lacks enforcement powers, Article 94 of the United Nations Charter states that if a party fails to comply with a judgment, the other party may seek recourse through the Security Council. The Security Council can make recommendations or decide on measures to give effect to the judgment. Compliance with ICJ decisions is generally respected by states, although there have been exceptional cases where states failed to fulfill their obligations.
This night is cold in the kingdom. I can feel you fade away. From the kitchen to the bathroom sinking, your steps keep me awake. Don't cut me down, throw me out, leave me here to waste. I once was a man with dignity and grace. Now I'm slipping through the cracks of your cold embrace. So please, please, could you find a way to let me down slowly? A little sympathy, I hope you can show me. If you wanna go, then I'll be so lonely. If you're leaving, baby, let me down slowly. Let me down, down, let me down, down, let me down.